And Ukraine's own response to Russia's third preliminary objection is essentially that it has made only adjustments in its memorial to its claims, but that these are permissible. Of course, the first we can see is that Ukraine does concede that it did make, I quote, adjustments to its claims. Indeed, Counsel for Ukraine admitted that the memorial's request to declare Russia's violations of the convention is an addition to what Ukraine claimed in its application. It is now undisputed that Ukraine made new claims in the memorial. The question then is whether these adjustments, additional claims, or new claims, or what have you, are admissible in line with the Nauru criteria as applied in Nauru and progeny. Ukraine does not contest, thus accept Russia's reliance on Nauru. However, its analysis fails to take into account the factors that Nauru judgment considered decisive for finding new claims inadmissible. I discussed these elements last Monday, and for convenience, let me just recall them here. First, the application is the basis on which it is to be determined whether or not a claim is new. As the court emphasized in Diallo, and I quote, "In this respect, it is the application which is relevant." Second, a new claim is inadmissible, is not inadmissible ipso facto. The decisive consideration is the nature of the connection between the claim and the one formulated in the application. Third, regarding the nature of such connection, to find that a new claim has been included as a matter of substance in the original claim, it is not sufficient that there should be links between them of a general nature. Fourth, to be admissible, a new or additional claim must have been implicit in the application or must arise directly out of the question, which is the subject matter of the application. Russia addressed each of the new claims it considers inadmissible based on the Nauru criteria. On the other hand, Ukraine, as I pointed out last Monday, could only muster in its written statement links of a general nature between its new claims and the original claim, and offer only conclusive statements with no concrete support that the Nauru alternative tests were met. Such general links and conclusive statements obviously are not sufficient to show that the new claims are admissible under the Nauru criteria. Last Tuesday, Ukraine did not go any further beyond what it did in its written statement. In fact, Ukraine remains evasive on most of the points raised by Russia and offers all over again statements on a general connection and conclusory assertions about the connection between the new claims and the original claim or the subject matter of the dispute. Nevertheless, let us take a look at Ukraine's assertions made last Tuesday. Ukraine's first assertion is essentially that its new violation of the convention claims are the no basis in the convention claims, or they are of the same nature. The first basis for this assertion seems to be a few phrases Ukraine seized upon in its application. In Russia's preliminary objections and in my presentation last Monday, we have made clear the glaring differences between the two types of claims. In any event, these phrases Ukraine seized upon are of no help to Ukraine. First, Ukraine claims that its assertion Russia's actions are incompatible with the convention is a claim that Russia violates the convention. Nothing can support this view. An ordinary meaning of incompatible is having basic differences. Of course, use of force and recognition of states are based on different bodies of law. And for this reason, they are incompatible with the convention. This, however, does not mean they violate the convention. Second, Ukraine states that its contention, Russia's actions violate Ukraine's rights, indicates that Russia violated the convention. This is also baseless. Even now, Ukraine fails to indicate a right envisaged by the Convention that Russia violated. Needless to say, the application did not point to that right and the provision of the Convention on which this right is based. Third, to support its purported claim on Russia's violation of the Convention, Ukraine relies on a vague submission in paragraph 30b of the application that Russia cannot lawfully take any action on the basis of the Genocide Convention. On the basis of the false claim of genocide. This reference does not help it either. It is common ground that the Genocide Convention does not provide a legal basis for use of force or recognition of states. However, Ukraine's declaratory submission in no way alleges Russia's responsibility under the Convention. Last Tuesday, Counsel for Ukraine attempted to rewrite the wording of its claim to say that Russia cannot lawfully take the action it was taking. The application does not contain such wording, "it was taking," or any other wording invoking Russia's responsibility under the Convention. Thus, the phrase "cannot lawfully take," read together with other phrases and other requests, means only having no basis in the Convention. The second basis for Ukraine's same claims assertion is that the court understood the nature of Ukraine's case in its provisional measures order, summarizing Ukraine's position as follows. The Russian Federation has acted inconsistently with its obligations and duties as set out in Articles 1 and 4 of the Convention. But as I pointed out last Monday, in the order on provisional measures, the court was not expressing an opinion, but simply relating what Ukraine argued orally during the hearing on provisional measures. In other words, Ukraine only mentioned such responsibility or Article 4 in its council statements post-application. This mention does not have the effect of retroactively invoking in Ukraine's application Russia's responsibility under Articles 1 and 4 of the Convention. As mentioned several times, the court has emphasized that in this respect, it is the application which is relevant. Ukraine's second assertion is that Russia's third preliminary objection flouts the law for three reasons. In the first leg of this assertion, Ukraine first recaps the Nauru criteria and then essentially asserts that the subject matter of the dispute is, and always has been, the same. Russia's reliance on allegations of genocide to justify harming Ukraine. That its submission arises directly out of Russia's actions in reliance on its allegations of genocide. That Ukraine's application asked for more than a declaration that Russia's actions lacked a basis in the Genocide Convention. But even if that had been the sole request, the question of whether Russia's actions could be justified under the Convention is closely related to whether those same actions violate the Convention. They stem from the same dispute. These statements only describe in general terms the general connection between the new claims and the original claim. They stem from the same dispute, or offer conclusory observations without proof that each submission arises directly out of Russia's actions in reliance on its allegations of genocide. This is not sufficient to meet the Nauru criteria. In making such assertions, Ukraine attempts to generalize or extrapolate the subject matter or dispute. I quote, "The subject matter of this dispute is, and always has been, the same. Russia's reliance on allegations of genocide to justify harming Ukraine." First of all, no such formulation appears in the application at all. Secondly, the main targets in the application, Russia's special military operation and recognition of the DPR and LPR, have been extrapolated as measures harming Ukraine. Ukraine apparently wants to cast the net widely and loosely so that it can take in all claims. However, such an approach violates Article 38(2) of the Rules of Court, which requires the precise nature of the claim to be specified in the application. Thirdly, it is also against the teachings of the World Court, this court and its predecessor in many cases. For example, Mavromatis says that a dispute is a disagreement on a point of law or fact. Where is the point of law or fact in such an overall subject matter? If I may paraphrase the term overall problem Iran used to describe its grand controversy with the United States in Tehran hostages, such overall subject matter must be reduced to a series of specific issues such that a court could deal with them to meet the requirements of the statute, the rules, and the case law of the court. Such an overall subject matter approach must be rejected, as the court rejected the overall problem formulation in Tehran hostages. The second leg of Ukraine's assertion is that Russia improperly focuses on the wording of Ukraine's requests for relief. It seeks help from a few phrases in the application and in different requests for relief. As the most important component in an application, the requests for relief are naturally the place for one to look for the real subject matter of the dispute, particularly when an application, as is Ukraine's, does not make the subject matter clear. In any event, as analyzed here, the phrases in the application and in other requests that Ukraine seized upon do not offer any rescue to its inadmissible new claims. In this regard, Ukraine resorted to Nicaragua versus Colombia as a precedent in its favor. But to the contrary, that case offers no help to Ukraine. Instead, it showcases why Ukraine's new claims are inadmissible. In that case, Colombia asserts that in its reply, Nicaragua changed its original request and that the new continental shelf claim was not implicit in the application nor in the Nicaraguan memorial. Colombia states that the question of Nicaragua's entitlement to a continental shelf extending beyond 200 nautical miles, hereinafter referred to as extended continental shelf, and the delimitation of that shelf based on geological and geomorphological factors cannot be said to arise directly out of the question that was the subject matter of the application, namely the delimitation of a single maritime boundary based solely on geographical factors. The court agrees that Nicaragua's additional claims are new, but proceeds to reject Colombia's objection to admissibility. Thus, and I quote, the court notes that the original claim concerned the delimitation of the exclusive economic zone and of the continental shelf between the parties. In particular, the application defined the dispute as a group of related legal issues subsisting between the Republic of Nicaragua and the Republic of Colombia, concerning title to territory and maritime delimitation. In the court's view, the claim to an extended continental shelf falls within the dispute between the parties relating to maritime delimitation and cannot be said to transform the subject matter of that dispute. Moreover, it arises directly out of that dispute. What has changed is the legal basis being advanced for the claim, natural prolongation rather than distance as the basis for a continental shelf claim, and the solution being sought, a continental shelf delimitation as opposed to a single maritime boundary, rather than the subject matter of the dispute. The new submission thus still concerns the delimitation of the continental shelf, although on different legal grounds. End of quote. Ukraine says that Ukraine's adjustments to its submissions here are far less dramatic than Nicaragua's change of request. Ukraine misses the point. As the court explains, the subject matter of the dispute in Nicaragua in specific terms, i.e., ultimate delimitation of the EEZ and of continental shelf between the two parties, has not changed. The only change is the basis for the claim and solution. Put another way, the method of delimitation. The different solutions are just different ways to achieve the ultimate result of delimitation. Here, in this case, there is no such close connection between Ukraine's new claims and its original claim, as we have shown in our preliminary objections and in my presentation last Monday. As a result, Ukraine's new claims are inadmissible. In this leg of Ukraine's assertion, in response to Russia's argument that by changing the request in the application for a declaration that no acts of genocide have been committed to a request in the memorial for a declaration that there is no credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention, Ukraine presented an inadmissible new claim. Ukraine simply asserts general connections between the two. I quote, "Both formulations arise from the same dispute with the same subject matter," or that the fact that Russia acted against Ukraine without any such evidence is relevant to Ukraine's claim of abuse, also an integral part of Ukraine's application. Such arise from or is relevant language denotes only general connections, which are insufficient to meet the Nauru criteria. The third leg of Ukraine's second assertion is that its failure to mention Article 4 in the application does not matter. Counsel for Ukraine argues that, and I quote, "Ukraine claims that Russia improperly sought to punish Ukraine and its officials as persons committing genocide, even though they are not such persons." Again, this claim arises directly out of the subject matter of the application. Russia's actions taken for the express purpose of preventing and punishing genocide. Madam President, distinguished judges of the court, what a surprising novel argument this is. We all know that Article 4 only deals with criminal punishment through the criminal process, or in the words of an intervening state among the 32 that have come to support Ukraine. And I quote, "Article 4, which provides exclusively for criminal measures against individuals, cannot be interpreted in isolation." Now, counsel for Ukraine appears to consider Ukraine as a person within the meaning of Article 4 and eligible for criminal punishment, and also considers the means Ukraine describes in the application, i.e., Russia's special military operation or recognition of DPR and LPR as measures of criminal punishment. Madam President, distinguished judges of the court, to tell you the truth, there's nothing in the application that can be considered remotely related to criminal punishment, not to mention under Article 4 of the Genocide Convention. Article 4 claims, in whatever formulation, cannot be considered to have been included in the original claim. And the court's mention of Article 4 in the form of relating what Ukraine said during the oral proceedings on provisional measures does not change this. Finally, Ukraine said this case, where the court has already found that Ukraine prepared its application in circumstances of extreme urgency, should not be the first to adopt Russia's rigid methodology. I would like to point out that calling the Nauru criteria Russia's rigid methodology is wrong. First of all, the methodology is not rigid. It is just right for the business of a court of justice. Secondly, it is not Russia's methodology, it is the court's rule of law. The court's rule of law does not take a break for any party. It applies continuously and equally to all. And so, in this case, too. Otherwise, the court will become just another hall of unwieldy discussion, as I mentioned last Monday. To conclude, Russia reiterates its request that the court declare inadmissible Ukraine's new claims presented in paragraph 170A, B to D, and paragraph 179, A to F of the memorial. Madam President, distinguished judges of the court, I now come to Russia's fourth preliminary objection. By this objection, Russia maintains that Ukraine's claims are inadmissible because any potential judgment from the court on these claims would be devoid of practical effect. And I say this with the utmost respect, the greatest respect for the court. The law on this issue is clear, and this court should only render judgments that can affect existing rights and obligations of the parties, thus removing uncertainty from their legal relations, or, put another way, judgments that will be capable of effective application or susceptible of compliance or execution. Russia has shown that any potential judgment that this court could render on Ukraine's claims made under the Genocide Convention would be devoid of practical effect. First, any potential judgment under the Genocide Convention cannot possibly or properly address the right of self-defense under Article 51 or of self-determination under Article 1 of the UN Charter and customary national law, over which the court has no jurisdiction, and therefore cannot affect the rights and obligations or remove the uncertainty in legal relations arising under these bodies of law. Second, any such potential judgment under the Genocide Convention does not prejudge the lawfulness of conduct under these bodies of law. And third, a decision made under the Convention cannot override Russia's inherent right of self-defense under Article 51, or the right to recognize states under the right to self-determination under Article 1 of the UN Charter and relevant customary international law, which are, no doubt, jus cogens. This has been noted early on in this very case. Without engaging these points directly and squarely, Ukraine on Tuesday resorted to a plethora of sideway assertions. Let us take a look at some of them. Ukraine's first assertion is that Russia mischaracterized the dispute and that Ukraine's claims are based firmly on the Genocide Convention. We can see that Ukraine firmly sticks a Genocide Convention label to its claims, for sure, but this does not mean that would suffice to make the dispute a Genocide Convention dispute. In fact, Ukraine has been playing a labeling game, while its real goal is to get the court to make a decision on and decree remedies for matters other than the Genocide Convention. As paragraph 179 of its memorial lays bare to us all, neither genocide nor Genocide Convention is mentioned once there, not even once there. The truth is, between Ukraine and Russia, there has been no dispute regarding the Genocide Convention to begin with. This is apparent even to an intervening state coming to help Ukraine. Thus, they note that neither party now argues in their submissions before the court that Articles 1 and 4 themselves authorize the unilateral use of force to prevent or punish genocide. I know that the Council said belatedly, but this is not true, as Russia already made clear the basis for its special military operation is the right to self-defense under Article 51 of the UN Charter in its letter sent to the Security Council before the filing of the application. Interestingly, given that recognition, that intervening state still claims that the court would have jurisdiction to declare the Russian Federation's so-called special military operation in Ukraine was not authorized by the Genocide Convention. Russia submits that with the agreement as noted, the court is not called upon to do more, and the declaration as suggested by the intervening state will be incompatible with the judicial function of the court. With due respect, this suggestion flouts the teachings of the court in Northern Cameroon's nuclear test, Chile versus Bolivia, as well as frontier dispute, Burkina Faso, Niger. We have earlier discussed Northern Cameroon's nuclear test and Chile versus Bolivia, in which the court essentially held that the court can exercise its jurisdiction in contentious proceedings only when a dispute genuinely exists between the parties at the time of adjudication. And when no dispute exists, the court is not called upon to proceed further. In Chile versus Bolivia, the court held, if the court finds that the parties have come to agree in substance regarding a claim or a counterclaim, it will take note of that agreement in its judgment and conclude that such a claim or counterclaim has become without object. In such a case, there's no call for a declaratory judgment. And in frontier dispute, Burkina Faso, Niger, the court specifically addressed a situation analogous to the suggested declaration here. In that case, Burkina Faso and Niger reached agreement described as entente on two sectors of the boundary between them before the institution of proceedings. And the special agreement provides that the court should place on record the entente reached by the parties at the end of their negotiations. Burkina Faso requested the court to include in the operative part of its judgment the line of the common frontier in the two sectors on which the parties have agreed, so as to endow this line with the force of res judicata, while Niger did not object but did not join in the request either. The court considered that such a request is not compatible with its judicial function. Here too, before Ukraine's institution proceedings, Russia made clear that its special military operation was based on Article 51 and Article 1 of the UN Charter and customary international law, rather than grounding the operation in the Genocide Convention. Similar to the requested declaration in frontier dispute, a declaration that Russia's special military operation in Ukraine was not authorized by the Genocide Convention would be incompatible with the court's judicial function. More than once, Ukraine attempts to turn Russia's preliminary objection on admissibility of its claims into a defense on the merits, such as Russia's argument being premature or Russia's basis for its special military operation being not clear. For its assertion, Ukraine points to the statements of Russian high-level officials made on TV or on social media. Ukraine ignores Russia's formal letter of 24 February 2022 to the Security Council or its formal letter to the court dated March 7, 2022. I have discussed this issue last Monday, and it bears reiterating that all the material makes clear and manifest that Russia does not ground its military operation in the Genocide Convention. The fact, i.e., the statements and letters, are not in dispute. They exist. The issue is what effect the court should give to them. Such an issue is eminently one for the preliminary objection stage, as the court held in border and trans-border armed actions, Nicaragua versus Honduras. The documents make it very clear that the Genocide Convention is not the legal basis of the special military operation. The legal basis for the operation that is mentioned in all the documents that specifically address this issue is Article 51. I emphasize, specifically address this issue is Article 1 of the UN Charter. The mention of genocide in some statements made on TV or on social media were not stating the Genocide Convention as the legal basis for the special military operation, but was for describing the serious situation of the relevant persons. Furthermore, Russia's letter to the Security Council was delivered through an established, specific and special channel for the very specific purpose under Article 51 of the UN Charter of solemnly informing the Security Council of the resort to the use of force in self-defense. And the letter to the court was delivered through an established specific channel for the very specific purpose of solemnly presenting legal positions to this august institution. These letters must be considered decisive for determining a state's intent in the use of force in self-defense and its legal position, respectively. Madam President, distinguished judges of the court, rhetoric on whom to listen aside, if TV and social media are prioritized over special, established, and specific channels, if statements made outside special, established channels are prioritized over specific positions made through special, established channels, the working of the international system, in particular, the standing mechanisms in place for specific purposes of dealing with the most serious, the most solemn business, use of force in self-defense and interstate dispute settlement, will be called into question. All this shows, as I have said last Monday, clearly and manifestly, that the Genocide Convention is not a legal basis for the special military operation. Finally, Counsel for Ukraine attempts to find some effect for a potential judgment of the court based on the Genocide Convention by essentially insisting on the Genocide Convention as a separate body of law applicable to the special military operation, and on the effect of the court's decision staying within that realm. In so doing, Ukraine steadfastly ignores Russia's third argument, i.e., the view that a decision made under the Convention cannot override Russia's inherent right of self-defense under Article 51, or in realization of the right to self-determination under Article 1 of the UN Charter and relevant customary international law, which no doubt are jus cogens, and that as a result, any pronouncement from the court on Ukraine's claims based on the Genocide Convention would be devoid of legal purpose or would be a wholly academic exercise, thus incompatible with the court's judicial function. A charge that a decision of this august institution, this Court of Justice, would be a wholly academic exercise is a serious matter. So much so that when faced with such a charge from the United States in Nicaragua versus the United States, i.e., a decision on the use of force and self-defense based on customary international law cannot be carried out as against the commitment made regarding the same point under the UN Charter, a multilateral treaty over which the court had no jurisdiction. The court seemed to acknowledge that this indeed may be a problem, but pointed out that on use of force and self-defense, any difference between customary international law and the UN Charter will not be such that a decision of the court cannot be carried out. In the court's own words, I quote, "The differences which may exist between the specific content of each are not, in the court's view, such as to cause a judgment confined to the field of customary national law to be ineffective or inappropriate, or a judgment not susceptible of compliance or execution. In stark contrast, here in this case, what Ukraine asks from the court under the Genocide Convention, such as termination of use of force, withdrawal of recognition of DPR and LPR, is diametrically opposite to Russia's actions taken under the right of self-defense and the right to self-determination, over which the court has no jurisdiction, which are, of course, jus cogens. As we know, self-defense is enshrined as an inherent right under Article 51 of the UN Charter, thus given supreme status in our current community of states. It is also given an exalted position even in the extreme tension situations described in the court's advisory opinion of 8th July 1996. And the fundamental character of the right of self-defense, and the fundamental character of the right to self-determination has repeatedly been stressed by this court in cases such as Chagos, war in Palestine, East Timor. Its status as jus cogens is well recognized, as testified to by the work of the International Law Commission. On the other hand, while the prohibition of genocide, i.e., the act within the meaning of Article 3 of the Genocide Convention, is no doubt jus cogens too, no such jus cogens matters are in issue in this very case, because no such acts are alleged. The obligation to prevent genocide is not yet jus cogens, as persuasively held by an arbitral tribunal composed of distinguished jurists, including a sitting member of this court, sitting right now here, and a former member of this court. And I quote, "Given the high threshold required to attribute jus cogens status to an international norm, it is not enough for the Respondents' Council to say why not include the obligation to prevent genocide as a jus cogens obligation. Turkey has not been able to point to any state practice which clearly supports the contention that this obligation has been recognized by the international community of states as a whole as one from which no derogation is permitted, nor has it shown any persuasive international judicial authority to that effect." End of quote. Ukraine's claims regarding alleged bad faith in performing such an obligation to prevent is one more level removed from the obligation to prevent, and is thus farther away from jus cogens. The measures Ukraine sought from the court are, at best, prohibition of jus cogens paraphernalia, not jus cogens proper. Prohibition of jus cogens paraphernalia, prohibitions of genocide paraphernalia do not have the status of jus cogens. As the court's 2012 judgment in Germany versus Italy clearly teaches, accordingly, any measures decreed by the court in a potential decision on Ukraine's claims thus would not possess the status of jus cogens, and thus could not, I emphasize, could not override jus cogens' right to self-defense or self-determination, as the court's potential decision on Ukraine's claims would be devoid of purpose. In light of all our arguments presented in our preliminary objections and in our presentations, any potential judgment on Ukraine's claims based on the Genocide Convention would be devoid of any practical effect. Madam President, this concludes my presentation. I have the pleasure to request that you give the floor to Mr. Udovichenko to continue Russia's presentation. I thank you for your attention.
I thank Professor Yi for his statement, and I now give the floor to Mr. Kirill Udovichenko. You have the floor, sir.
Madam President, members of the Court, it is an honor for me to appear before you today on behalf of the Russian Federation. I will respond to Ukraine's submissions on Russia's fifth and sixth preliminary objection, as well as on the alleged violations of the Court's provisional measures order. I will start with the issue of inadmissibility of Ukraine's reverse compliance claims. Ukraine only opposed it by stating that the rights of nationals and the Lockerbie cases should apply to Ukraine's claim. Other than that, no objections were voiced. I will then limit my presentation to these remaining issues. The rights of nationals is an irrelevant and bad authority for Ukraine, not least because in this case, the US chose not to object to France's reverse compliance claim. Instead, it pursued a counterclaim that France breached the applicable treaty, and further dispute revolved only around this positive statement. The Lockerbie case may require a bit more attention, especially given that recently it has been invoked by the United Kingdom, a party to that dispute. So in Lockerbie, Libya asked the court to declare that it had fully complied with all of its obligations under the Montreal Convention, and that the United Kingdom had, in turn, breached and is continuing to breach its legal obligations to Libya under a number of articles of the Montreal Convention. So how did the United Kingdom respond? It objected against Libya's non-violation complaint and stated that the United Kingdom never itself invoked the Montreal Convention. Specifically, it went on arguing that, I quote, "An assertion by the state that it is acting in accordance with the treaty does not itself create a dispute between that state and another party regarding the application of that treaty." May I remind you that this is the United Kingdom arguing in Lockerbie against the admissibility of a reverse compliance request. This is the same United Kingdom that now, together with Ukraine, suggests that in the Lockerbie judgment, the court has accepted Libya's reverse request. However, the plain text of the judgment suggests that the court simply excluded Libya's non-violation claim from the scope of the dispute. This has not been done manifestly, but both a general and a specific description of the dispute by the court, which you see on the slide, do not even remotely refer to Libya's compliance with the Montreal Convention. What the court did do manifestly is limit its competence to cover only Libya's claims concerning the United Kingdom's alleged violations of the Montreal Convention. I quote, "Indeed, it is for the court to decide, on the basis of Article 14, paragraph 1 of the Montreal Convention, on the lawfulness of the actions criticized by Libya, insofar as those actions would be at the variance with the provisions of the Montreal Convention. Naturally, actions criticized by Libya can in no way imply Libya's own compliance with the Montreal Convention. Russia accepts that there are matters where this matter can be interpreted in two ways. One is that the court did not pronounce on the admissibility of the reverse compliance claims at all. The other is that even if it did so in a manner not allowing such claims. In either scenario, the Lockerbie judgment supports Russia's case, not Ukraine's. Another statement which requires some scrutiny is Ukraine's argument that, unlike the Genocide Convention, the Montreal Convention did not contain the express indication that any of the parties to the dispute may seize the court. Well, the compromissory clause in Article 14 of the Montreal Convention is very clear in this respect. I quote, if the parties are unable to agree, any of those parties may refer the dispute to the International Court of Justice by request. So there is no real difference between the Montreal Convention and the Genocide Convention as regards to who can bring the claim. Article 9 of the Genocide Convention, just like Article 14 of the Montreal Convention, in the Lockerbie case, sets out the scope of Russia's consent to the court's jurisdiction. The scope of jurisdiction means that if two states have divergent views as to the interpretation, application, or fulfillment of the convention, either can then refer the issue to this court. Russia has never argued that only Russia can invoke Ukraine's responsibility under the convention, while Ukraine can never invoke Russia's responsibility. What Russia did argue, however, was that the claim shall be filed by a state that invokes responsibility of the other state. A state cannot invoke responsibility under the Genocide Convention by claiming absence of its own breach of the convention. Likewise, a state cannot preempt any further responsibility of its own for genocide by obtaining a negative declaration that such genocide was not committed. Ukraine's criticism that Russia had sufficient time, that is 8 years, to investigate and gather evidence of genocide in Donbass misses that point. The point, however, is that no one can take from the state its sovereign right to decide if, when, and how it wishes to bring a claim. Finally, I also note that the interveners argue that a state can file a premature non-violation claim in order to, I quote, clear its name. Now, I cannot align myself with the idea that this court, being a proper place for handling some states' reputational issues. Clearly, further elaborations on such suggestions appears to be excessive. Madam President, this concludes my final comments on Russia's fifth preliminary objection, and I would now move to the sixth. Ukraine did not raise much objections to Russia's abuse of process argument. In essence, it asserted that, I quote, Russia's allegations of abuse add nothing to its other objections. It is rewarding to see that the parties agree that abuse of process, upon reaching a certain magnitude, may compel this court to dismiss the claim. As Ukraine stayed silent on the substance of Russia's statement, I have nothing to rebut. Instead, I'll use this time to demonstrate how the representations of Ukraine and of the esteemed interveners contributed to Russia's abuse of process objection. It is undisputed that a claim once filed with the court must be precise and carefully tailored. The applicant may not appear before the court with a fragmented set of factual and legal allegations and demand to put these pieces together. Yet, the second day of hearings have left us with nothing but a variety of these puzzles, sometimes so contradictory that one may start wondering whether they even come from the same set. Ukraine attempts to give the court as much room for interpretation of its claims as possible. Certainly, in some fora, this whatever works tactics might be permissible. But it should not be so before this esteemed court. Here, it should be recognized and treated as abuse. Example. When discussing existence of dispute between the parties under the convention, Professor Koh claimed that, I quote, that broader group of disputes would include, for example, the questions relating to responsibility for genocide here. Is Ukraine, as Russia alleges, really responsible for committing genocide? Or is it Russia that violates its duties under the convention by falsely alleging that Ukraine is committing genocide, end of quote. For this, one may conclude that there is probably a number of disputes, a broader group. But this impression is wrong, according to Mr. Zions, who asserted that the subject matter of this dispute is, and always has been, the same: Russia's reliance on the allegations of genocide to justify harming Ukraine. Quotation ends. Voila, a single dispute, without any indication whose responsibility it pertains to. Second example. Ukraine claims that Russia violated Article 4 of the Convention. However, it fails to clarify which actions fall within the scope of this provision. Professor Ko states that Ukraine further claims that Russia violated Article 4 by invading Ukraine to punish a genocide based on the false allegations that Ukraine's officials are persons committing genocides for the purposes of Article 4. End of quotation. Accordingly, it appears that Ukraine's case on Article 4 relates to Russia's accusations against Ukraine's officials. But Mr. Zients steps away from this understanding and broadens the scope of Ukraine's allegations under Article 4. Ukraine claims that Russia improperly sought to punish Ukraine and its officials as persons committing genocide. End of quote. Now, it is unclear whether Ukraine considers that an action against the state, and not only against its officials, may also be qualified as punishment for genocide under Article 4 of the Convention. Well, third example. Ukraine intentionally keeps it unclear whether the alleged dispute between the parties relates to responsibility of Russia or responsibility of Ukraine under the Convention. During the oral arguments, Ukraine's position appears to have drifted to a statement that Russia violated Article 1 of the Convention by acting on the false allegation that Ukraine committed the international crime of genocide, which Russia became obliged to prevent and punish. End of quotation. But that's not how the matter is perceived by, for example, the intervening states. Germany stated, I quote, "When the case was brought, Ukraine and Russia undoubtedly held diametrically opposing views as to whether or not Ukraine was responsible for the acts of genocide on its territory." Right after Germany, Australia took the floor and failed to ascertain the limits of the alleged dispute. The point of present importance is that the competing claims reveal a dispute about at least the application or fulfillment of Article 1 and 4 of the Convention with respect to Ukraine's alleged conduct. End of quotation. So, is it Russia or is it Ukraine's liability we are looking into? The further we go, the more confusing Ukraine's position gets. And I submit that this is done on purpose. But making controversial statements is one way of puzzling the court. The other way is evading a definitive statement where this is essential. For example, Ukraine does not say whether use of force is allowed by the Convention. In his presentation last week, Professor Tuvenin stated that Ukraine certainly does not contend that the Genocide Convention prohibits the unilateral use of armed force by one state against the other. Just a couple of minutes later, he added that Ukraine is not arguing that Article 1 of the Convention confers a right to use force. This is an elaborate way to say that the claimant simply has no position on the matter, which is essential for its claim. Whatever works. Finally, Ukraine fails to demonstrate consistency and floods the court with a spawn of ideas on what is allegedly the legal basis of Russia's responsibility. Is Russia responsible because of violation of obligation or abuse of right under the Convention? At paragraph 73 of its memorial, Ukraine accused Russia of abusing an undertaking. 3 paragraphs later, of abusing a right. Or perhaps the legal basis for responsibility is Russia's misuse of the treaty's provisions. Or is it their misapplication? Does Russia misuse its duties or undertakings under the Convention? Or, as Ukraine claims in paragraph 92 of the memorial, misapplies them? Or is it abuse of the entire Convention, or misuse of it, or misapplication, whatever of those terms might mean? We still have no answer to these questions, as Ukraine, in words of its counsel, is adjusting its case. Perhaps a constructor for Ukraine's position would look something like the table you can see on your screen. Well, and this well echoes with what Russia argued last week. Ukraine has been elusive and inconsistent from the start. Inadmissible new claims were introduced by Ukraine in its memorial. They invoked new provisions of the convention to which Ukraine failed to refer in its application. But again, this issue has already been dealt with last Monday. So was the matter relating to fabrication of evidence. That is a statement of Ukraine's Ministry of Foreign Affairs in which it allegedly opposed Russia's statements. The one that was published just a couple of hours before the filing of the application. Russia has already explained that the dispute already existed by then. Such evidence would not be necessary. Ukraine now attempts to stress that the publication was made, and I quote, before filing its application with the court, although it is clear that the 3-hour difference makes this filing virtually simultaneous. Finally, Ukraine argues that the intervention complaint has already been permitted by the court by virtue of the order dated 5th June 2023. This argument misses the point. What the court decided is that Article 63 of the statute is drafted in a manner that does not give it much leeway in dismissing the declarations of intervention. The court did not rule on whether Ukraine's puppeteering the matter in which the interveners were plotted, rallied, and executed is an abuse. Neither Ukraine nor the interveners have rebutted that interveners got engaged in this case upon Ukraine's direct request. The court does not have any alternative than to proceed on the basis that these states acted in collaboration with Ukraine from the very beginning. But it is not only the abusive process, not the only abusive process committed by the interveners. The court's order on the permitted scope of the intervention was disregarded. Several states, including Germany and Australia, which I have already cited, as well as, for example, Portugal, dwelled upon the issue of existence of dispute, something nobody authorized them to do. Other states impermissibly devoted their speeches to substantive issues unrelated to jurisdiction. Australia, Lithuania, the United Kingdom, and others addressed the Convention's purported obligation to assess the risk of genocide with due diligence before taking actions to prevent genocide. Plenty of states discussed states' obligation to apply the Convention in good faith. Some of the interveners, such as Canada and the Netherlands, even raised the issue of Russia's compliance with the provisional measures, which is a substantive issue that has nothing to do with the court's jurisdiction ratione materia. Now, and remarkably, New Zealand's oral presentation was devoted solely to the provisional measures order. Some states, such as Latvia, even assumed the role of co-applicants, continuously supporting the position of Ukraine's counsel and referring to Russia's many arguments as something that, I quote, must fail. Many intervening states, including Germany, Australia, Canada, the Netherlands, Poland, Lithuania, and others, used the court as a tribune for political pronouncements. Perhaps most illustrative in this regard is Lithuania's condemnation of the Soviet Union, which of course included both Ukraine and Russia. However, propagandistic statements have never been a permitted scope of interventions under Article 63 of the statute. Finally, as you may see, states whose positions were almost word for word identical decided to replicate them over and over again. This has been done in ignorance to the court's request for joint statements, which specifically tackled such scenario. What is even worse, we have seen no indications that the interveners wanted to interpret the Convention. They proclaim that they want to seize the opportunity. They stressed the fundamental importance of interpretation. However, none of them has intervened in any of the past 15 cases that were brought under the Convention in this court. None intervened for 4 years while this court has been considering the Gambia versus Myanmar case. As you know, the matter is still pending. A lot of the states who intervened in this case had a chance to present their views on the interpretation of the conventions in the legality of the use of force cases where claims were filed against them. However, then, they did not seem as interested in the convention or its proper interpretation. Instead, they challenged the court's jurisdiction. The representative of the UK went as far last week as to say that, I quote, "It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression." These words would have been very appropriate in the legality of the use of force cases. Do not get misled. In the present matter, the intervener's intent is purely instrumental. Madam President, members of the court, Russia has shown that each procedural step of the Ukraine bears a stigma of manipulation of the proceedings. From the preparation to file this application and until the present oral hearings, Ukraine has acted and continues to act abusively. There could be no greater evidence, no more exceptional circumstances to uphold the abuse of process objection. I now move to my final submission and address Ukraine's statement related to the alleged violation of the court's provisional measures order. There is no reason not to keep it brief. You have heard counsel for Ukraine asserting that Russia has no respect for the court, that it defies and challenges the court as an institution. However, we are here precisely because Russia holds this court in high regard and relies on international law. Unlike Ukraine, Russia does not invent any new concepts or unprecedented arguments. To the contrary, what it requires is that the court upholds its established jurisprudence. And this concerns not only the application of the legality of the use of force cases. This approach is just as fair for Ukraine's arguments regarding the court's provisional measures order. Such established jurisprudence is straightforward. There is no place for deliberating over compliance with orders for provisional measures at the jurisdictional stage of the proceedings. Russia did not focus on such allegations earlier precisely because the present phase of the case has nothing to do with them. An inquiry into whether provisional measures were violated requires factual determinations. As Judge Yusuf emphasized in Qatar versus UAE, issues of fact are normally a matter for the merits. In that case, Qatar accused the UAE of violating the court's provisional measures order both in its memorial and at the preliminary objection stage. Qatar developed a long argument which resembles the one advanced by Ukraine now. The court, however, did not address this claim in its 2021 judgment, where it rejected jurisdiction over the matter. There is no reason for Ukraine not to be aware of such approach. In fact, it is the second time Ukraine attempts to escalate this issue while the case is at its preliminary objection stage. In the 2019 judgment, in the ICSFT third case, the court indicated that issues of compliance with the provisional measures order, I quote, may need to be addressed by the court at the later juncture, should the case proceed on the merits. This 2019 judgment on Russia's preliminary objections contained no determination whatsoever concerning Ukraine's allegations. Madam President, members of the Court, the same approach has been followed by you in the Treaty of Amity case, which is still pending. The 2021 judgment on preliminary objections records that the Court, and here I quote once again, considered that any issues relating to the implementation of the provisional measures may be addressed at the later stage if the case proceeds to the merits. The approach is no different if the case concerns the Genocide Convention. In Gambia versus Myanmar, Gambia too argued that Myanmar has failed to comply with the Court's provisional measures order. The Court again did not address this matter in any way in its 2022 judgment on preliminary objections. All this leaves no doubt that Ukraine's arguments on the alleged violation of the provisional measures order are misplaced, at the very least. There is one further point raised by Mr. Gimblett that I must address. He argued that a court can exercise jurisdiction over provisional measures even if there was no jurisdiction in the original case. Reference was made to the request for interpretation of the Avena judgment case. However, as you may see on the slide, what the court really stated is that if the jurisdictional basis in the original case has lapsed, the court may still interpret its own judgment under Article 60. The verb lapsed was used for a reason. It presupposes that something has existed in the first place. Therefore, jurisdiction in the original case is still a must. Unless the court finds jurisdiction over the present claim, the court's order in the aforementioned case is of no avail to Ukraine's position. Madam President, this concludes my presentation. I thank you for your attention, and unless you find it appropriate to have a coffee break, I kindly request that you call Maître Jean-Charles Chikaya to the podium.
I thank Mr. Dovichenko. Before I invite the next speaker to take the floor, the Court will observe a coffee break of 10 minutes. The sitting is adjourned.
To attempt, as the other side has done, to fit the facts of this case to the Procrustean bed of the compromissory clause is both artificial and vain. The interveners have repeated incessantly that their construction of Article 9 is broad. Yet they should know full well that their contention is inconsistent with the way the court has defined its jurisdiction versione materia in the past. The interveners have focused on Ukraine's claims regarding the use of force. They have said nothing about the issue of the recognition of the DPR and the LPR. It would appear that Ukraine's attempt to transform the object of the Genocide Convention has become all too obvious. The key to Russia's second preliminary objection has been entirely ignored. Pursuant to Article 9, the court may only entertain disputes relating to breaches of the Convention itself. It lacks jurisdiction with respect to alleged violations of other rules of international law. Many interveners have argued that the court has jurisdiction to determine if the Convention authorises the use of force, yet neither of the parties in the instant case has claimed that the Convention permits the use of force. In other words, this question is devoid of relevance. The real question is whether the court has jurisdiction to make a determination on the lawfulness of actions which, according to Ukraine, were undertaken to prevent or punish genocide pursuant to rules of international law other than the Convention itself. Herein lies the disagreement between the parties. Russia's view is that the court's jurisdiction ratione materia under Article 9 does not cover such issues. Might I immediately emphasize an aspect of juridical policy of the utmost importance? A broad construction of the compromissory clause, as the interveners would have it, would considerably broaden the substantive scope of the Convention. It would allow all sorts of states to refer other states to the court by relying on the compromissory clause. For instance, Serbia could bring an action against the NATO member states who used force in 1999 with the stated aim of preventing genocide. States accused of genocide, such as Myanmar, might seize the court to challenge the lawfulness of the unilateral sanctions imposed upon it. States, as Mr. Alfredo said this morning, states whose national courts have launched criminal proceedings for acts of genocide in accordance with universal jurisdiction might be brought before this court for alleged violations of customary international law rules on the jurisdictional immunity of high-ranking officials of the state. Can one reasonably consider that the 1948 Convention has such a broad normative scope? Would the intervening states themselves accept that such an extensive projection of this convention and of its compromissory clause is part of substantive international law? I doubt it, as indeed was made known by NATO member states in cases concerning the use of force. I do not doubt that the court will not be swayed by such an interpretation of the convention. Let me move on to the correct interpretation of Article 9 of the Convention. Madam President, let us look at the interveners' construction of Article 9 of the Convention. Their view is that Article 9 is a one-of-a-kind compromissory clause which confers upon the court greater jurisdiction than do other provisions on the settlement of disputes. Firstly, we need to determine the actual meaning of the word fulfillment in Article 9. The interveners have laid great store by this issue. But this term adds nothing to the term application. The ordinary meaning of the word fulfillment is the application of a rule in accordance with its provisions. The court has the power under all compromissory clauses to determine whether an obligation has been performed, even if the word fulfillment is not actually used. Thus, Article 9 does not confer broader jurisdiction upon the court simply because it contains the term fulfillment. The court has stated more than once that it does not have the power to rule on international law breaches other than those which arise from the Convention itself. Thus, in its 2007 judgment, the court indicated clearly that the term fulfillment is not relevant to the establishment of its jurisdiction. This ought to be the end of it. Secondly, some interveners have referred to the effet utile principle, claiming it should lead to giving a separate effect to the word fulfillment. But the effet utile principle cannot be invoked when there is no discernible distinct meaning to be given to a particular term, or when the travaux préparatoires of the treaty drafting give no indication of any such intention. The court stated in an earlier case that it can happen that parties to a treaty adopt a provision aimed at dissipating any doubt, even if such a provision is not strictly necessary. Considerable caution must be exercised when the effet utile principle is invoked to extend considerably the court's jurisdiction. And finally, why should the effet utile require that a meaning be given to the word fulfillment, which would go beyond the Convention? What is it that has to be applied or fulfilled? Rights and obligations contained in the Convention, nothing else. Even if one were to insist on the effet utile, one could not go beyond the scope of the Convention. Thirdly, the interveners have argued that the object and purpose of the Convention should lead to a broad interpretation of Article 9. They have relied extensively, broadly, if I may say, on a passage in the 1951 Reserve's consultative opinion. The only real question is whether the object and purpose can be used to broaden the scope of the court's jurisdiction pursuant to Article 9. The answer is no, they cannot. The court has been quite clear on this point. The fact that certain rules are particularly important and have an erga omnes or jus cogens character is not sufficient to confer upon the court jurisdiction to entertain a case. This view was confirmed in the Croatia genocide case. The court has also ruled that the text of the Convention clearly indicates that jurisdiction under Article 9 is restricted to disputes relating to the interpretation, application, or implementation of the Convention, no less, but also no more. As to the travaux préparatoires for the drafting of Article 9, there is one certainty. The drafters did not intend to extend the court's jurisdiction to cover disputes which fall outside the Convention's provisions. That goes without saying. In the Bosnia genocide case, Judge Tomke quite rightly observed that the travaux préparatoires did not add anything juridically relevant, and that the inclusion of the expression fulfillment of the present convention to the compromissory clause added nothing to the substantive obligations of the parties to the convention and flows from the notion of application of the convention for interpreting the term fulfillment. And the travaux préparatoires did not broaden the court's jurisdiction ratione materia. Judge Oder also observed that, and I quote, there was a certain amount of confusion among the drafters of the convention, namely due to the unique nature of their task and in view of the state of mind that prevailed at the time. Ukraine's and the intervener's position that the travaux préparatoires support a broad interpretation of this provision must therefore be rejected.
Fourthly, the interveners also relied on two authors. They do not mention other authors who openly contradict that position, such as Judge Greenwood. But even the two authors that were mentioned do not support their viewpoint. No meaning is provided to the word fulfillment, says one author. The other author says that the word fulfillment doesn't add anything decisive to the text. It could mean, at best, an application that meets the requirements of the standards. The word fulfillment is not significant for the determination of the court's jurisdiction, as the court itself confirmed in the Bosnian genocide case. And he concludes that Article 9 does not cover only covers disputes under the Convention, but disputes relating to other rules of international law, even when they relate to allegations of genocide. In sum, neither the Convention's text nor the travaux préparatoires support the interpretation of Article 9 suggested by the intervening parties. Even the court's jurisprudence runs counter to this interpretation, as does its doctrine. Fifthly, some interveners, such as Greece, contended that the important role of the court under Article 9 of the Convention would require a broader interpretation. Once again, they referred to the separate opinion in the Congo versus Rwanda case, in which 5 judges who indicated that the court, and I quote, has an important role to play under the Genocide Convention, unquote. Nobody denies that the court plays an important role in the settlement of disputes, of all disputes, but this important role cannot take precedence over the principle of consent. This appears clearly in the court's decision in the present case. In that case, France's position as a state intervening of Article 9 warrants more attention. France contended that, indeed, that the French version of the text is to be taken into consideration because the expression relating to genocide is broad enough to include both its commission and its non-commission. Moreover, the term including suggests that other dispute categories can fall within the scope of Article 9. End of quote. However, in its preliminary objections filed on the 4th of July 2000, in the lawfulness of the use of force case, Bosnia and Herzegovina, versus France, France had argued that Article 9 of the Genocide Convention could not be relied on to establish the court's jurisdiction. At the time, France contended by applying very rigorous legal logic that, and I quote, by claiming to rely on this convention to establish that the court has jurisdiction in the present case, the Federal Republic of Yugoslavia is instrumentalizing the 1948 Convention and its compromissory clause and is breaching the principle of good faith. And that it is using this convention to take France to court, even though these accusations are essentially based on alleged breaches of the United Nations Charter and on breaches of certain principles and rules of applicable international human law applied to armed conflicts that cannot in themselves establish that the court has jurisdiction. End of quote. Well, we have to admit that it is very surprising for the country where Descartes was born to contradict itself to such an extent. O tempora, O mores, O the times, O the customs. Finally, some interveners contended that Article 9 requires a broad interpretation because it does not impose any precondition to the seizing of the court. However, it is the preconditions for the seizing of the court, such as negotiations, that have no bearing on the scope ratione materia of the court's jurisdiction under the compromissory clause. So this is common knowledge. I would now like to address my second point, which is the obligation to act within the limits of international law. Does the Convention encompass an obligation to act within the limits of international law, as Ukraine suggests? If indeed this is the reading of the Convention, then one would also include other rules of international law into the Convention. Virtually all the interveners repeated, just like Sweden, that a state cannot claim to apply international law by violating international law. Germany went a step further and declared that Article 9 applies to conflicts relating to an unlawful action, but which is justified to prevent and punish genocide. However, this question is not included in the scope of the 1948 Convention. Everything that is more or less connected to genocide, or supposedly so, is not automatically included in the scope of the Convention. The UK seemed to suggest that Article 1 of the Convention does not include the obligation to act within the limits of international law, but only within some of the rules of international law, in particular the UN Charter. It is unclear where this distinction comes from. The Convention does not contain any provision that would include United Nations law in its material scope. And even when the UN organs are mentioned, for instance in Article 8, no obligation is specified as to the obligations. Therefore, no dispute can arise on this issue under the Convention. Some interveners added that Article 9 gives effect to the parties' pre-existing obligations under the UN Charter for peaceful settlement of disputes. However, one cannot conclude from this that the Convention includes other rules of international law. One can say that all compromissory clauses give effect to the principle of peaceful dispute settlement. But this has no bearing on the court's jurisdiction ratione materiae under these clauses. Otherwise, compromissory clauses would have the same scope as voluntary declarations of mandatory jurisdiction devoid of any reservations. Some interveners referred to the oil platforms cases. The court had noted that questions relating to the use of force are not in themselves excluded from the scope of application of the 1955 treaty. This case, however, is not relevant to the claims that Ukraine has made in the present proceedings. The oil platforms case focused on Article 20, paragraph 1d of the 1955 Treaty of Amity between Iran and the US. This provision allowed for specific defense pertaining to the issue of the use of force. The key point in this case is as follows. The court was able to examine the question of the use of force and self-defense because Article 20 of the 1955 Convention authorized it or even obliged it to do so. The same does not hold true for the 1948 Convention. Furthermore, Ukraine isn't simply asking the court to interpret the convention in the light of other rules of international law. Ukraine wishes the court to use its jurisdiction to decide whether Russia has violated the rules of international law other than those in the convention itself, and Ukraine wishes that the court should draw all the legal consequences from this exercise. The interveners also refer to the military and paramilitary activities case, and in particular to the court's statement according to which the use of force is not the appropriate method to supervise and ensure respect of human rights. However, this recital is not relevant to the present case. Yet again, the applicable treaty was the Treaty of Amity, containing a provision similar to the one that I just mentioned in the Iran versus USA case. Cyprus's position was rather odd. Cyprus suggested that an obligation to act within the limits of international law would exist based on an analogy with countermeasures. According to Cyprus, Article 1 of the Convention constitutes a form of countermeasure in the face of genocide, and as a consequence, measures taken based on Article 1 should comply with international law. This argument can be refuted very easily. Indeed, Article 1 does contain a primary obligation, but it does not incorporate law on countermeasures or the law on international responsibility into the Convention. Moreover, as the court held, the obligation to prevent applies even if genocide has not been committed yet. Of course, Ukraine will continue to argue that its claim is based on a breach of Article 1 and 4 of the Convention and not of other rules of international law, but that only makes sense if we accept that Article 1 and 4 include other rules via the implicit obligation to act within the limits of international law. I think that we have sufficiently demonstrated that such an obligation cannot reasonably be found in this convention. Some interveners relied on Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties. Bulgaria, for example, suggested that by using the provisions of Article 9 would provide the court with jurisdiction on compliance with acts carried out by a contracting party within the framework of the legal system in its entirety. This interpretation confuses systemic interpretation with the question of limits to the court's jurisdiction by virtue of the compromissory clause. Article 3, paragraph 3c of the Vienna Convention on the Law of Treaties cannot be relied on to extend the court's jurisdiction ratione materia. Other interveners, such as Austria, emphasize that it is not necessary to establish whether Russia's conduct is relevant under other rules of international law. In the present case, what matters is that the court has jurisdiction to rule on whether Russia's conduct is compatible with the Genocide Convention. However, the interveners did not address the key issue, that is, does the Convention govern the rule of force and the recognition of states or not? The obvious answer is no. The court cannot ascertain the lawfulness of Russia's conduct under the UN Charter and under customary international law, because by doing so, it would overstep the material scope of the applicable convention and the principle of consent.
Let me address the third part of my presentation now, Madam President. Some rather remarkable propositions were made to this effect. On the issue of the prohibition of identified allegations, some interveners argue that rather than make abusive allegations of genocide without having performed its due diligence obligations, the state may seize the competent bodies of the United Nations. But seizing the United Nations on a genocide issue would necessarily require an allegation of genocide or of threat of genocide. This argument goes round in rings. There has to be an allegation. That is inevitable. The idea that states must provide substantive or conclusive evidence of a genocide or threat of genocide prior to or at the time of making an allegation is equally unconvincing. As observed Judge Benuna, and I quote, "The genocide concept has been overused, utilized left, right and centre by propagandists of every ilk, and that," and I quote again, "in none of its provisions does the Convention cover genocide allegations or the use of force based on such allegations," end of quote. Allegations of genocide are frequent among states, and more often than not without the slightest evidence. It would be unreasonable, therefore, to consider that the court might be seized for each of these past or future allegations unless the state in question is able to provide conclusive evidence of genocide or threat of genocide. This distinction does not in the least appear in international practice, as I've said. To conclude, a simple genocide allegation, be it abusive, true, or mistaken, does not constitute in itself a breach of the Convention. Russia and Ukraine appear to agree on this point, at least at this juncture of the proceedings. The interveners are not in a position to pinpoint a right provided by the Convention which might have been subject to an abuse. I shall be a little more brief on this, Madam President. This argument by Ukraine has a major failing. Ukraine cannot pinpoint a right under the Convention which might have been subjected by Russia to an abuse of rights. In particular, the Convention does not cover the use of force or the recognition of states. If there is no applicable law, there is no possibility of abuse of this non-existent right. This is a matter of logic and should encourage you to reject Ukraine's claim on this issue, that of the abuse of rights. The court must determine the exact scope of Articles 1 and 4 of the Convention, in other words, if they govern the use of force or the recognition of states. And since they do not, these actions do not fall within the scope of the Convention. Thus, the Convention must not be used abusively or in bad faith in this respect. In the last part of my presentation, I would like to point to, and this was done a moment ago, to what I would call the violation by the interveners of the court's order, authorizing them to intervene. With blatant disregard for the court statute, the rules of the court, and the court order dated 5th of June 2023, the interveners persist in broaching issues that they have no right to comment upon. The merits of the case, the existence of a dispute between parties, the admissibility of the application, and the application of the Convention in this case. A couple of examples. In the almost identical written observations, Belgium, Croatia, Denmark, Estonia, Finland, Ireland, and Luxembourg and Sweden all brought up the issue of the use of force and its link to Article 1 of the Genocide Convention and the due diligence obligations of a state under that same article. These are issues which clearly bear no relevance whatever to this stage of the proceedings, since they belong to the merits, assuming the merits stage is ever reached, of course. Ireland has gone one step further by simply ignoring the court's order. Ireland has provided the court with its own interpretation of Ukraine's submissions. Basically, Ireland has not interpreted the provisions of the Genocide Convention, but has tried to help Ukraine by attempting to correct Ukraine's clearly defective conclusions and has requested that the court rule on the merits in a given way. Throughout the hearings, the interveners, such as Germany, openly talked about the existence of a dispute. For example, German said, "Suffice it to be noted that when the case was brought before the court, Ukraine and Russia had undoubtedly diametrically opposed views as to whether Ukraine was or not responsible for acts of genocide committed in its territory. Germany, and I continue to quote, therefore considers that there is a dispute under Article 9 of the Convention. The interveners also improperly raised the issue of the application of the Convention in the instant case with regard to jurisdiction. Germany, yet again, said, and I quote, the question before the court today is solely to determine if it has jurisdiction to examine this case. Germany is firmly convinced that it is. That it does, rather. Australia. I quote, the first point is that a dispute regarding the scope, content and performance of obligations arising from Article 1 and 4 of the Genocide Convention falls within Article 9. More specifically, a dispute regarding the scope or content of these articles concerns, by definition, the construction of the Convention, whereas a dispute regarding the performance of obligations arising or supposedly arising from these articles pertain to the application or performance of the Convention. In this case, and that is the agent actually speaking, Article 9 is engaged on both issues. Greece. In its first part, Greece said the word concerning requires only that the subject matter of the dispute is alleged breaches of the Convention. Thus, when, as in the instant case, an application concerns the consistency of certain actions with the Convention, the court may exercise its jurisdiction under Article 9, distinctly from the issue of whether this conduct is also in breach of other rules of international law, and the question as to whether the court has jurisdiction to entertain these matters. All these questions go clearly beyond a simple interpretation of Article 9 or the scope, ratione, materia of the Genocide Convention. They relate to the merits of the case. The interveners were not even at pains to disguise their abusive conduct and their actual purpose in joining these proceedings as interveners. And here, the idea was indeed to help Ukraine, whereas one might have expected from the interveners to shed some additional light on international law, in particular the question of construction, which the court is examining today. New Zealand declared that there is a dispute between the two countries and Article 9 of the Convention, and Ukraine rightly submitted this dispute to the court. New Zealand has felt at liberty, it seems, to characterise Russia's preliminary objections as, and I quote, significant false declarations. New Zealand repeated this view during the oral proceedings. Its agent even went as far as to say, and I quote, I do not intend to repeat all our points made in our written observations. I shall not either repeat the points made by Ukraine and other intervening states. We simply broadly support the points they made, end of quotation. Portugal, rather than providing the court with an actual interpretation of Article 63 of the Genocide Convention, has even made observations as if it were co-applicant. Portugal argued that application concerns existing dispute, B, the dispute concerns implementation, application, formation of the Convention, C, the dispute concerns the substantive obligations which arise from the Convention, D, the application was appropriately filed by one of the parties to the dispute. Further on, Portugal made a conclusive declaration stating that a dispute under Article 9 of the Convention clearly exists between Ukraine and the Russian Federation. Portugal persisted during the hearings and said the Portuguese Republic is of the opinion that the dispute in question relates to substantive obligations under or connected to the Convention. End of quotation. And finally, Lithuania. No comment, I would say. Lithuania defends the respect of the territorial integrity of another state. That is Lithuania speaking, and opposes the defendant's disregard for international law by giving false pretexts based on the Genocide Convention that form the gist of this case. End of quotation. This is how these interveners have perverted Article 63 of the statute, which might have brought them, if that was their purpose indeed, to shed further light on what all the states parties must consider to be the law with regard to these provisions. Before closing, Madam President, may I briefly recall my main submission. The 1948 Convention, as can be seen from its provisions, governs nothing but genocide. It does not extend to actions or conduct governed by other rules of international law, including the Charter of the United Nations. The Court's jurisdiction under Article 9 of the Convention is restricted to alleged breaches of the Convention itself. Madam President, distinguished members of the Court, this concludes my presentation. May I thank the Court for its kind attention. And Madam President, may I ask you to invite the agent of the Russian Federation, His Excellency Ambassador Alexander Shutkin, to take the floor for the final submissions of the Russian Federation.
I thank Mr. Chikaya, and I now invite His Excellency Mr. Alexander Shulgin, agent of the Russian Federation, to address the Court. You have the floor, Excellency.
Madam President, distinguished members of the Court, I have the honor to conclude the presentation of the Russian Federation's arguments and to announce our final submissions. The Russian Federation's agents and counsels have consistently and comprehensively explained why Ukraine's claims in this case cannot go beyond the preliminary objections stage and why they are doomed to fail. Indeed, any other decision by the Court other than this one would allow states not to rely on their real rights and obligations under the treaty, but to instrumentalize all sorts of foreign concepts, such as misuse, abuse, and this would pave the way for frivolous proceedings on all sorts of matters. This would upset the system of compromissory clauses and would enable states to circumvent very easily the principle of consent of states to the Court's jurisdiction. What is even more dangerous is that in an attempt to invent an allegation of abuse of rights against Russia, Ukraine alleges the existence of a discretionary power, into inverted commas, under the Genocide Convention to, and I quote, act to the detriment of other states, end of quote. That could even include the use of force. It goes without saying that the Court cannot rely on such an assumption. Ukraine and its 32 partisans did not change the fact that Ukraine's claim does not rely on the Genocide Convention, and that when Ukraine seized the Court, no dispute between the parties existed on the claims submitted to the Court by Ukraine. Its lawyers are now forced to look for posts on the Internet to support the contrary by insisting on the fact that Russians supposedly used the Convention as a legal basis, notwithstanding the obvious fact that the Russian Federation has relied on the UN Charter for its actions. The intervening states, in a blatant display of duplicity, have attempted to pervert the functioning of the compromissory clause of the Genocide Convention by brazenly making a turnaround on their previous positions before this very court when NATO bombarded Yugoslavia under the pretext of preventing genocide in Kosovo without making any reference to the United Nations Charter. The intervention of the 32 states who simply repeated Ukraine's position shows that Ukraine does not have faith in its own legal arguments and is in fact counting on this unprecedented attempt at exercising collective pressure on the court. This attempt must fail. I will now recall the 6 preliminary objections that the Russian Federation has submitted to the court. First, no dispute existed between the parties because Ukraine has never made the Russian Federation aware of its claims before filing its application, and therefore the Russian Federation was not aware of a dispute with Ukraine before this critical date. Secondly, Ukraine's claims do not fall manifestly under the court's jurisdiction ratione materiae under Article 9 of the Convention, in particular because these claims do not involve breaches of obligations under that convention. Thirdly, the new claims submitted by Ukraine in its memorial are inadmissible and largely demonstrate that Ukraine itself did not know on what grounds it was really making its claims at the time of initiating proceedings. Fourthly, the court's potential judgment would be devoid of any effet utile because a judgment delivered under the Convention cannot affect the rights and obligations of states under the United Nations Charter and under customary international law. And it is these instruments that Russia has relied on for its actions. Fifthly, Ukraine's claim based on reverse compliance is inadmissible given that states are not allowed to request preventive judgments that protect them from the establishment of possible breaches. Sixthly, and finally, Ukraine's case constitutes an abuse of process for a host of different reasons that our counsels have enumerated. Madam President, what matters is that the court confirms its own jurisprudence, that is to say, that the use of force and the recognition of states are not within the scope of the Convention. Before moving to the final submissions of the Russian Federation, I would like to express our gratitude to the court's registrar and his staff for their precious assistance, and I would also like to thank the interpreters for their excellent hard work and their devotion. We would like to thank all the members of the court for paying attention to Russia's arguments. Madam President, I now have the honor to read Russia's final submissions. And I quote, "Having regard to the arguments presented by the Russian Federation in its preliminary objections and during the hearings, the Russian Federation respectfully requests the court to adjudge and declare that the court lacks jurisdiction to entertain the claims made by Ukraine against the Russian Federation in the present proceedings, and or that Ukraine's claims are inadmissible. End of quote. This concludes the Russian Federation's final submissions. I thank you for your kind attention.
I thank the agent of the Russian Federation, whose statement brings to an end this afternoon's session. The court takes note of the final submissions which you've just read out on behalf of your government. The court will meet again on Wednesday, 27 September 2023 at 3 p.m. to hear the second round of oral argument of Ukraine. At the end of that sitting, Ukraine will present its final submissions. The sitting is adjourned.